Good morning. Let's see, this is, I think Mr. Smith on Lamar Henry. Good morning.
Good morning.
And so Ms. Henry was previously in court in cause number 24, DCCR 1668, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I've received that pre-sentence report. Has everyone had an opportunity to review that report?
Yes, sir.
Are there any additions or corrections?
No, Your Honor. I'll finish that.
Ms. Henry, I've got some real concerns about your criminal history. You've been very busy in Louisiana, haven't you?
Yeah,
Yeah,
that's my past.
that's your past. Well, your past isn't that long ago on some of these. Some of them are old, some of them are not. And so I want you to understand that if I go along with this agreement and put you on this probation, that you will be on zero tolerance. That means you cannot miss an appointment, you cannot test positive, you cannot do anything that's a violation of your probation, or you will be in here on a motion to revoke your probation. Do you understand?
Yes, ma'am.
All right. Okay, then I'm going to find that you entered your plea of guilty previously, freely and voluntarily.
Yes, ma'am.
Find sufficient evidence to find you guilty, and at this time follow the agreement that you made. Find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over. You'll be able to serve that 10-year sentence while you're on probation. The other side of that, though, is that you've already agreed to a 10-year sentence. So any violation of your probation could end up with that 10-year sentence that you've agreed to. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Oh, wait, I have to hand you one more thing. Also, I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. Read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or how long that lasts, you can talk with Mr. Parker.
Okay.
Okay? So have a seat here in the courtroom, and probation is going to call you up when she's ready to go over your paperwork.
Thank you.
Good luck to you, ma'am. Good morning, sir. You're Joseé Contreras.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Good luck, Your Honor.
That's for Anna. And that's Mr. Contreras, in cause number 25, DCCR 0006, you're charged with the state jail felony offense of failure to comply with sex offender registration requirements, and that's from June 13th of 2024. How do you plead to that charge?
Yes,
Are you pleading guilty freely and voluntarily?
ma'am.
And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Speak up.
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 4-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Contreras is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. Okay, we'll see you back at sentencing. And then, Mr. Parker, you have Jeremiah Davis. Mr. Parker, Mr. Jones, make sure you
You
call.
got it, Your Honor.
Okay.
I have it. It's from.
Mr. Jones, make sure you get with, thank you, Mr. Nichols, make sure you call, make an appointment to go see Mr. Parker, so that y'all can go over everything so we can get an announcement at the next court date. Okay? You're free to go. And then you've got Stephen Wilburn, Mr. Parker. Stephen Wilburn, you come up, sir. Mr. Wilburn, in cause number 24, DCCR 2346, you're charged with the third-degree felony offense of driving while intoxicated, third or more, and that is from September 27th of 2024. The indictment alleges you were previously convicted of driving while intoxicated November 24th of 1998, June 29th of 1999, and then again April 26th of 2000. And how do you plead to that charge?
Guilty.
And are those prior convictions true?
Yes.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? And do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 10-year term in prison that would be probated for 6 years. You would have a $1,000 fine and be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Any evidence Mr. Wilburn is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom, and she's sitting at that desk right over there. All right? We'll see you back at sentencing.
Thank you, Judge.
Alan, did I get discovery on that one? Alan. Good morning. This is Mr. Smith's on Jamal Fontenot. And sir, you are Jamal Fontenot?
Yes.
And Mr. Fontenot is charged with burglary of a habitation in cause number 24, DCCR 2250. And what is the announcement?
We have received the media, Judge. He has an appointment with my office this coming Thursday to come view that media. So
Okay.
we can kind of get on the same page about what that looks like. If I could just have a resetting to give you time to
Sure.
do that.
Any
And
issue?
an offer extended draw.
And
Okay.
we do have that offer. as well.
Perfect. All right, I'll just reset, normal reset. Mr. Fontenot, make sure you go make that appointment so you can look over everything that your attorneys received, and we'll see if we can get an announcement at the next court date. Okay, we'll see you then.
Thank you, Judge.
Thank you,
May I
ma'am.
have excuse?
Yes. See, Mr. Burbank, you have Renisha Chason. Renisha Chason. And Ms. Chason is charged with 24 DCCR 2351. She's charged with injury to a child, elderly, or disabled individual. And then there's a motion to revoke probation in 19-33107. And so I know there's a co-defendant.
Judge, if I may, the co-defendant was actually sentenced to pen time last week.
Okay.
Mr. Nichols was able to take care of that for me.
Okay.
Last Monday morning, which puts us in a much better position with respect to Ms. Shashawn. Everything has been going well since she's been out on bond. I have extended an offer that was different from the one that before Mr. Williams pled. So I think we're pretty close here on this, hopefully.
So,
And to be honest with the court judge, last week kind of threw me a little bit because of the days and that. I just need to talk to her and this will be resolved.
okay, so just a couple weeks.
That'd be fine.
Okay, we'll do about a 2-week reset. Make sure you get in touch with Mr. Burbank, go visit with him about everything, and then we'll get your case taken care of at the next court date. Okay?
And I anticipate, Judge, with the court's permission, a dismissal on that motion when she resolves the underlying case. It was the only thing in the motion.
Okay, sounds good. Thank you for being here. Good morning, you're Jermaine Young,
Yes, ma'am.
and this is 24 DCCR 0916. Mr. Young is charged with aggravated sexual assault of a child. Mr. Burbank?
Last time we were here, we were waiting for some records. I've received some of them. I need to talk to Mr. Hoffman. Can I just have a short recess so that I can see if we can? This is getting old. and
It is.
I know that this court does not want to set it until there's a drop dead trial.
Yes, I just want y'all to visit before court day.
Last week, as I say, but
Okay. Ms. Malfino? Any?
I don't have an update additional to
Okay.
that. Judge, if Mr.
Patricia
Hoffman
Benton.
ends up being tied up this week, I'm happy to speak with Mr. Burbank.
Okay, perfect. So I'll just do, this will be the last reset. It'll be a normal 30-day reset. Give you plenty of time to visit with Ms. Malfino, Mr. Hoffpower. Make sure you visit with Mr. Burbank before that next court date so that y'all have a plan on what to do on your case when we come back, okay? All right, thank you. Yes. Good morning, you're Glenn Hicks. And Mr. Hicks was previously in court. This is cause number 25 DCCR 0369. Entered a plea of guilty to the third-degree felony offense of assault, family violence by impeding breath or circulation. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes.
Any additions or corrections? All right, Mr. Hicks, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have the felony conviction on your record. And if you successfully complete the probation, at the end, the case gets dismissed. The other side of that, though, is if you violate any condition of probation, when you come back, you could be brought back into court, found guilty of the offense, so you would be a convicted felon, and you could go to prison for anywhere between 2 and up to 10 years. Do you understand?
Yes, ma'am.
I want to make sure you understand that you are also, part of your probation is not to have any contact at all with Jeannie Marie Corpus. So I don't know what the status of that relationship is, but it's over if it's not already. She cannot give you permission to violate this order, okay? So she can't say, it's okay, I want to get back together, or anything like that. You cannot contact her in person. You can't have communication on your phone or Snapchat or whatever it is. Do you understand?
Yes.
Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to just have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over all of your paperwork. Good luck to you, sir. Good morning. How are you?
Good, how are you?
Good.
Judge, Mr. Jones is not here. We have an offer for dismissal for restitution. I spoke with Mr. Jones on Friday and told him about that. He said he needed about 2 weeks to get that money in. I told him we can come today and ask for the reset, but he had to be here. Got a phone call this morning. I just saw a message right now. He was in the hospital apparently yesterday and he cannot be here this morning.
Okay.
No response, John.
So his bond, what I'll do, I'm going to forfeit his bond for non-appearance and reset it at $100,000. If he gives you, I need some confirmation that he was in the hospital or still in the hospital or something. And then I'll recall that. So he needs to get that to you pretty quick.
Yes, ma'am.
Okay, thanks. Deshandra Joseph, Mr. Rojas. Good morning, you're Deshandra Joseph. And this is 24 DCCR 0708. Ms. Joseph is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
We signed a rejection.
Oh, is there something on the tablet? Can y'all check the tablet, please?
Nothing on our tablet.
Great.
Here it is.
Okay. So, again, Ms. Joseph, what you're charged with is a state jail felony offense, and that's from February 20th of 2024. And what that means is if you go to trial and you're found guilty, the range of punishment could be between 6 months and up to 2 years in a state jail prison. Do you understand? Yes. And I think I'm about to have something, maybe.
Four.
What? It's gone.
Four deferred.
Oh, okay, I was about to say, it can't be that. Okay, and so, somewhere there is a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 4-year deferred probation. You have every right to reject that and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. Do you understand all of that?
Yes.
Also, I want to make sure you understand that once I put your case on the trial docket, then I won't accept this plea agreement after today. So if there's unless there's a change in some information that your attorney or the state's attorney gets, do you understand that as well?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay, we'll get it set for trial, and Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him. I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Rojas, you're released. Ms. Joseph, if you'll have a seat over here on this side of the courtroom, the clerk will call you up in a few minutes with that information.
Yes, ma'am.
And so do we have it?
Yes.
You got it? Okay.
And there it is, another morning in Judge Raquel West's courtroom, where freedom, accountability, and second chances hang in a fragile balance. Each defendant walked forward with a past behind them, and a future waiting to be written. Some received mercy, others were warned, and a few now stand one choice away from losing everything. But that's the truth of this room. Every signature, every sentence, every promise becomes a turning point. Because in the end, the law can offer direction, but only they can choose who they become next. So the question remains, will they rise or repeat?